guys, welcome back to my channel. Now today's video is a little different. It's about something that almost every law student knows. They know what it is, but they may not know how it is done effectively. It's called as IRAC analysis. Every law student, and I can vouch for that fact, must have done this at least once or probably multiple times when they were in their law schools. So today's video will tell you not only what is IRAC analysis, but also how to do an effective IRAC analysis which will ensure that you're able to score a better grade. Now, knowing what is IRAC analysis, as in what each of the letters stand for, is not a difficult thing, but knowing what goes into each segment and putting them in the right proportion, in the right manner that would help you fetch more marks, that will improve your grades, is something that we learn from practice. Now, before I start talking about each of these components separately, let me tell you why is IRAC analysis important. Now, IRAC analysis basically is your way of telling your reader or whosoever is going to read this IRAC analysis, you are trying to break down the legal complexities of language, statutory law, judicial precedents, and you're trying to break them and make them into smaller textual blocks. You're going to make it simple for anybody who wants to know about that case. So whether you're trying to explain a case to a layman, somebody who does not have a background in law, you are using a case or a judicial precedent to adhere in a court of law while you are arguing before a judge, or simple when you are a law student and you are asked to write an IRAC analysis. Now, as a law student also, IRAC analysis can surface in two scenarios. One is where you will be given a case, an established decided case, or you may be asked to choose one, and then you're required to do an IRAC analysis. On the other hand, you could also have let's say a question in your exams where they may give you a factual scenario, and based on that factual scenario, you may be asked to do an IRAC analysis of that problem. So the approach will be slightly different when you're doing it for an actually decided case vis-a-vis when you're doing it for a hypothetical one. So let's look at what the process is. The first component of this analysis is I. Now, I represents an issue. Now, what is an issue? Now, issue in the eyes of law can either be an issue of law or it can be an issue of fact. Let me give you an example. The situation before you is that person A broke into person B's house. So, in such a scenario, your question of fact would be, did A enter into B's house? That is your issue of fact, because you're trying to determine a fact and whether it happened or not. An issue of law based off the same scenario would be that did A's entering into B's house amounts to trespass. Now, trespass being a legal term, being a punishable offense, you will want to know that all the components that categorized an entry into another property as trespass, were those provisions complied with when A entered into B's house? So determining that question will become your issue of law. So when you're drafting this segment, now a lot of students or people tend to consider this as a simple segment, they do not deliberate a lot. But I'll tell you, if you set out the tone properly in the issue segment as well, doing the remaining analysis becomes very easy. I'll tell you how. First of all, you need to understand and identify, and this obviously works better if you are working on a hypothetical case scenario, not on a previously decided case. If you are being given a question in your exam and you're being asked to do an IRAC analysis, you would want to find out that which is that one question, or probably a couple of questions, answering which you will be able to decide the manner in which the case will be decided. So if the question before you is, the previous example that I just talked about, trespassing or A entering into B's property, if you were to decide out of a factual matrix that what will be your issue for the purpose of IRAC analysis, just try imagining which will be that question, answering which, whether you answer it in the positive or negative, but answering that question will help you decide the manner in which that case will be resolved. So what will be the judge's decision be? That should give you a hint of what should be the issue. Now let's talk about how do you put this issue, how do you incorporate that into your assignment or your legal brief. You are supposed to frame issues as narrowly as possible. You're supposed to articulate the legal issues that are there. Now what do I mean by articulation? By articulation, I mean that you have to be very concise, to the point and focused on what the question is. If you believe that this one question can be broken down into multiple questions, please go ahead and do that. Do not write one long sentence which has a couple of portions separated by commas or semicolons. Try breaking down, because what you're trying to do with this analysis is you're trying to make the reader easy to understand what case or what hypothetical scenario you're analyzing. So the easier you do it, the better you break down the issues, your ruling part and your analysis part becomes much easier. So you need to ensure that you're writing them in concise form, and also because it is an issue or issues, it is imperative that you put them in a question form. So issue part will always be a question. It will not be a neutral statement. So for example, in the example that I just talked about, the issue will be, did A enter B's property ? That's how your issues are supposed to be framed. When you're looking and you're trying to cull out issues in a given factual scenario, issues can pertain to a wide variety of scenarios. For example, it could be an issue of jurisdiction. Does this court have the jurisdiction to decide this case? That can very well be an issue. Did this happen? Something based on facts. Anything dependent on the parties. So did A commit the act, or the date, or the incident? Any questions that revolve around these can very well be broken down and synthesized into issues for the purpose of IRAC analysis. The second component is R. Now R stands for rule. Rule basically can be a legal rule, and the source of this legal rule can either be a statute, a written law, or it can also be a judicial precedent. You're basically required to identify which rule of law, which provision of law or principle of law will apply on the facts of your case. Now identifying the correct rule becomes immensely important, because only when you've identified the correct law will you be able to impart or apply this rule on your facts that you've identified in the prior section, and you will be able to do a proper analysis. So rule becomes important. Be sure to include each and every possible single detail that you may have about the rule. For example, if the rule has two approaches, let's say there's a traditional approach vis-a-vis a modern approach, do mention that in brief. If there are exceptions to the rule, please mention those as well. If the rule contains, let's say, components, essentials or factors, be sure that you mention each of those factors individually. You're basically trying to uncurl or unravel the complexity that is there in that legal rule, so that even a layman, when he reads the facts of the case coupled with the issue that you've identified and the rule, it should come easy to him that what is the likelihood of the decision going to be. He may not know about the analysis part, because that will involve obviously the understanding of law and provisions of law, but based on identifying the correct rule and applying that rule over your issues, you are likely to come closer to your conclusion. Let me continue with the same example. So when we're talking about the rule part in the IRAC analysis, if you were talking about the trespass example, if there is a law in the penal code that categorizes trespass as a punishable offense, or there is a principle in law, there's a customary principle that says that if you enter into somebody's property without their permission, without their consent, it amounts to trespass, then that will be your relevant rule. So you have to find out that what the person did, whether that amounted to any offense under the law or not. And as I said, that law can be a statutory law. So there could be a section XYZ which says that yes, trespass amounts to a punishable offense, or there could be a precedent, there could be a court decision that says that yes, when a person enters into another person's property, then it amounts to trespass. The third component of this analysis is A. Now A stands for analysis. It can also be considered as analysis, or some people also like to use application. So A in IRAC can either be analysis or it can be application, or it could be a good idea to combine both. I will talk about analysis first. Now when you talk about analysis, your primary focus should be on the arguments that each of the sides proposed before the court. It goes without saying that this line of thought applies when you're doing an IRAC analysis for a decided case. However, if you're doing it for a hypothetical scenario, you will want to find out that what will be the two sets of opposing arguments that the petitioner and the defendant are likely to present before the court. So in such a case, obviously you will have to put on the hat once of the petitioner and once of the defendant and try to think from their side and propose arguments that will help you get a decision which is in your favor. So that amounts to analysis. Application is basically, it's more relevant in cases of judicial precedents, where in the analysis part, if your main focus is not on the statute, but it is more on a judicial pronouncement, a decision of the court, you will want to look at how the court has picked up or culled out the relevant keywords and how the court decides to apply those keywords in the given factual scenario of the case. This can apply in both cases, whether you're doing it for an already decided case, which may have relied on earlier decided precedents, or it could also be for hypothetical case scenarios where you're, let's say, where you're attempting an exam or you're solving a paper or something of that sort. In such cases also, you may want to look at earlier decided cases, identify the relevant keywords and look as how those keywords, whether they will apply to your facts of the case or not. So in any segment of analysis, you're supposed to concentrate on three parts. One is what your arguments are, arguments from respective sides, both the sides. Second would be your judicial pronouncements or decisions that are relied upon by the parties. And thirdly, if you feel there is a need, you can also include counter arguments in your analysis part. Or when you're doing in the application part, you may want to identify the relevant keywords that you're relying on through various decisions, and you will want to see how those keywords or phrases apply onto your facts. For example, continuing from the same example, in the trespass case, when you're analyzing whether it is a punishable offense or not, the petitioner in whose house the forced entry was there, from that side, you could consider the aspect of right to privacy. The fact when it is your own personal property, you are allowed the right to privately enjoy it. And when somebody enters into that property without your permission, meaning thereby that either your property or your own self, your person, may be under some sort of danger, then it will definitely be a problem in the eyes of law. So that could be your argument from the petitioner side. From the defendant side, you could, since if it is established that B did enter A's property, you may want to look at exceptions to trespass. For example, if you've already detailed in your rule that there are certain exceptions to criminal trespass, you will want to identify one of those exceptions as the defense, and you may want to cite that before the court. For example, you can say that it was to prevent the commission of an offense, and assuming that this is an exception in the eyes of law, that you're allowed to trespass. For example, a lot of times how police does it, if they are doing it when they have suspicion that some offense is going to be committed, they may not have the time to get a search warrant or an entry warrant. They may have to trespass, and so that the person does not go to the court saying that this was a criminal trespass and seek damages, the other party, the police in this case, may want to take the help of the exception to criminal trespass that the statutory law may recognize. The fourth and the final component is the C. Now C stands for conclusion. Conclusion is pretty straightforward. You basically have to answer the question that you raised in the issue part, the first part that you identified. You have to answer the questions either in positive or negative. For that, obviously, you will need to recap your analysis part, because that will provide the reasoning and it will set the context as to why you have reached that particular decision. So if you continue with the same example of trespass, let's say the court says that B was justified in entering in A's property. You will want to give the reasoning as well. So conclusion cannot be just one line saying that yes, B was justified in entering, or A does not have a right to claim damages. You will have to substantiate by saying on what basis, because of what reason is the court going to arrive at that conclusion. If you're doing it for an already decided case, the job is pretty simple for you because the conclusion or the decision of the court is already there. You will want to identify what was the imperative part in the analysis that helped you reach that conclusion. However, if you're doing it for a hypothetical case scenario, you may want to predict the court's decision. You may want to take sides whether it will be in favor of the petitioner or it will be in the favor of the defendant, and what will be your line of reasoning. Now please understand that providing the reasoning is very, very important because it sets the context in which your decision has been given. Decisions are not, they're not encompassing, they're not holistic. Obviously, decisions are contextual. In this case, it will depend upon the context. For example, if the court is going to is not going to allow A to press charges against B for trespass, they will look at the context which allowed B that exception. Probably another third person who may not have access to such an exception will be considered if the similar scenario would have been there, and the person B would not be a police officer but would have been an ordinary private citizen. Then obviously the exception under law would not apply. So conclusion is going to be dependent based on the context in which your analysis is going to be set. Apart from IRAC analysis, there are various other forms of providing this legal analysis as well. For example, you may also come across the acronym FIRAC, where F stands for facts. So it's nothing but simply a summarization of the facts before you discuss the issue of the case. Obviously, this makes more sense when you're doing it for a hypothetical scenario where you're provided with a set of facts and you're supposed to conduct a analysis. So in such cases, instead of IRAC, you could also do a FIRAC, where F stands for facts. Another version or another modification of this traditional IRAC approach is also the CRRACC approach. Now in this, the first C stands for conclusion. This is your bare bones conclusion. You're simply going to state that did A trespass B's property or not. So your conclusion can be very simple, saying that is B liable or B is not liable. The R of CRRACC stands for identifying the correct legal rule. The same way as we do it in the IRAC analysis, we identify the legal rule. The second R stands for explaining of that rule or substantiating that rule from the source or the authority where that rule is coming from. For example, if we are talking about trespass, let's say we are talking about trespass as a tortious claim, then your source authority becomes the law of torts. Or if you're talking about criminal trespass, then in the Indian context, it could be the relevant provision in IPC. The A stands for analysis, and it will be done in the same manner that analysis in IRAC is done. The C, the first C in CRRACC, stands for counter arguments. What are the counter arguments that each of the parties are going to present in order to rebut the other party's proposition or arguments? And the final C stands for any contrary approach that you may want to discuss, something that's different from the approach you've already taken, the stand you've already taken. Any opposition to that and any justification for that opposition is what forms the last part. So this is also something that a lot of students, especially this is something practiced in the Western legal schools, for example Harvard, etc. They tend to follow CRRACC as well because sometimes it is believed that IRAC sometimes oversimplifies the analysis. So to give it some credentials and to still have it some legal value, a lot of schools, a lot of places prefer CRRACC over IRAC. The last thing for this video before I close for today is to give you an example. Now I did already break it down, an example of trespass which is based on a hypothetical scenario. I will want to also discuss a very landmark case in the law of torts, which is the case of Donoghue versus Stevenson. So if you were to asked to do an IRAC analysis of Donoghue versus Stevenson, this is how you're going to do. The issue will be, did Donoghue, which was the person who had accepted, so she was basically drinking ginger ale from a glass bottle which was opaque, and later on some decomposed portion of a snail was found in the bottle. As a result of that, she had suffered some form of stomach infection, and she claimed damages from the manufacturer of that bottle. Basically, that bottle was bought from the distributor who had again passed on that to a restaurant owner. So the court basically was trying to identify the issue of manufacturer's liability. The question that was posed before the court, which will become your issue in the IRAC analysis, will be that is Stevenson liable to Donoghue for the damage? That becomes your issue. rule will be the rule of negligence. Now there are 4 components to negligence. There's a duty, there's a breach of that duty, there's causation. It was because of your breach that the damage was caused, and 4th is your damage. So this becomes your legal exposition or your legal rule. Now what you're supposed to do, you have identified the facts, the rule is before you, you have to now apply the rule over the issue of your case. So the issue is, was Stevenson negligent towards Donoghue? And your rule is rule of negligence. You break down your facts into those 4 components, apply each of them over the factual scenario in your analysis part, and based on that you will be able to identify that yes, the court did agree upon something called as manufacturer's liability. Why and what you can explain in more detail in your analysis part. And finally, based on your analysis, the conclusion will be that yes, Stevenson was held liable by the House of Lords to pay damages to Donoghue for the damage that was caused. So that's all for this video, guys. If you like this video, please like, comment, share and subscribe. If you want more such videos on specific topics, do let me know in the comment section, and also don't forget to hit the notification bell, as I will be posting regular videos every weekend. Thank you for watching.